Well, good afternoon or good morning, depending on where you are. My name is Tim Sullivan, and I am working this afternoon with my partner, Jeff Newman, to present a webinar on GSA schedule contracting compliance. The program is CLE certified, which is important for many of you, we know. I am the chairman of the Government Contracts Practice Group at Thomson Coburn. Jeff is one of our senior partners. We both deal with a variety of matters in the federal contracting sector, and including the federal supply schedule, and we're delighted to be with you today for this program. We're ready to get going, and this afternoon we're going to be giving you a general overview of the schedule program, the GSA Federal Supply Schedule program. We're going to identify the key issues and clauses related to that program. We're going to talk about minimizing risk and bring you up to date at the end on some recent developments. And we know we only have 50 minutes to cover a topic that deserves a lot more, but we hope we'll hit the high points for you. Jeff?
Hello, everyone. It's nice to be with you today. In talking about a few introductory items relating to the GSA schedule program, I thought we would run through a few basic concepts, sort of what is the GSA schedule program, what does it mean for contractors, how do you get a schedule, before jumping into some of the key clauses and provisions of your schedule contract. Real briefly, the GSA schedule contract has a significant number of different schedules that contractors can apply for a contract under. Those schedules are generally categorized by different products and services being offered to the federal government customers. Two examples we put on the slide in front of you is MOBIS, Mission-Oriented Business Integrated Services, or FABS, Financial and Business Solutions contracts. Those are two of the larger GSA schedule contracts, along with IT, the Information Technology Schedule number 70. And the GSA schedule contract provides the government with the ability to purchase commonly used off-the-shelf items and services easily and inexpensively. The competition is already done, terms and conditions are already established, and all the federal customer has to do is access the online catalog or contact a GSA schedule holder and begin the process of acquiring the supplies or services. Just for further background, there are millions of products and services provided under the schedule. There are over 20,000 schedule contracts been awarded since the start of the program, and that's approximately $50 billion worth of contracting dollars are spent under the contracting program each year, and that's 10% of the overall federal procurement spending in the United States. For those small businesses on the phone, 80% of contract holders under the schedule are small businesses, and they account for 36% of the sales under the GSA schedule contract. Once you have a schedule contract, or what we call the hunting license, you're able to compete for or be presented with task or delivery orders, tasks for services, delivery for items, and that's the way you go get new business. As I mentioned before, one of the benefits of the schedule program is the terms and conditions have been negotiated. Competition has already occurred in many cases, and if there is a follow-on task or delivery order competition, you have to go through that process again. But there is no agency publication required under FBO.gov like a standard or more traditional contract led under FAR Part 15 as an example. All there has to be is a fair opportunity to be considered. Usually 3 or more offers are considered for award for a task or delivery order, and then the federal customer may be able to place the order with the contractor. And the orders are issued by an individual agency contracting officer. The contracting officer is the individual within the federal government that has authority to bind the government contractually. The schedule program, interestingly, although administered by GSA, all sales of supplies and services under the schedule are handled by the individual or component agency. So if the Department of Interior wants to buy some information technology equipment, the contracting officer from the Department of Interior will reach out to the contractors who have the equipment that the agency is looking for. We'll contact them directly and effectuate the purchase. We'll get into in a little bit the role of GSA in managing and administering the schedule contract.
Jeff, can I
Sure.
Jeff, could I add just a couple of points there? If you're wondering where the federal supply schedule is covered in the Federal Acquisition Regulation, it's really in FAR 8.4. There are other parts of the FAR that come into play. For example, I don't believe Jeff mentioned BPAs, blanket purchasing agreements, which are very commonly used by agencies. They're basically a charge account. If you're awarded a BPA, now you've got the agency has a charge account with you, and they just bill against it. They just order against it. BPAs are covered in FAR Part 13, for example, and once again, even though it is a much simplified process, it does bring other parts of the FAR into play, and you should acquaint yourselves with those. The final point I want to make before we move on is that once you've got your GSA contract, that means they've negotiated the pricing with you. For purposes of further competition, it's already determined as a matter of law to be fair and reasonable, which is an important step in the award process. So that step is taken care of. However, agencies are allowed to ask you for better pricing, and they commonly do it when they hold competitions between and among federal supply schedule holders.
And that is entirely correct, Tim, especially with regards to the further price competition. As I mentioned before, it's a second bite at the apple, and that's been one of the criticisms of the program, and there are several, but one of the criticisms of the program is you go ahead, you do all this work to get a schedule contract, and then you're required to compete again for a follow-on task or delivery order. And so part of that is just the normal government contracting process, but part of that is, as we'll discuss on this slide in front of you right now, is the ability to network and leverage your current customer base to demonstrate the value added that your products bring to the table. Before we get to that, however, let me just sort of take a few moments to talk about the process of acquiring a scheduled contract. At the outset, let me highlight the fact that although Tim and I are lawyers, you do not need lawyers to get yourself a scheduled contract. This is really a business process, a function of your company's willingness to download the scheduled documents from the GSA's website. They're all available on the GSA's website. You could download the full set of documentation that you need. Usually it's the contract, solicitation and the contract documents with a whole set of attachments. Certainly, attorneys can be helpful in terms of discussing certain terms and conditions, but generally speaking, to submit an offer for a GSA scheduled contract award, that is something that is often handled and frequently handled by the business folks. You find your solicitation on FBO.gov, but probably the best place to start, as I mentioned, is the GSA website. The Federal Supply Schedule website has links to FBO.gov. It'll then sort of present you with the different, as I said, contract documents that you'll need to complete. One piece of advice we often give to clients, however, is do not read your solicitation like a novel. It'll be a very short novel because you'll probably be sleeping after 3 pages. What you want to do is go ahead and read a couple pages, in your first pass of the document, put it aside, do something else, come back, because, as I said, it's a very laborious document, lots of terms and conditions, lots of things that you need to fill out, and we generally recommend that you read a few pages at a time as you go through the document to spare yourself this sort of burdensome process. Once you get the documents in place and you fill out the application, so to speak, it generally takes about 90 to 120 days, depending on how long the backlog is at the particular schedule you're dealing with to get your scheduled contract award. And there's a couple sort of subcomponents of that. First is, and we find the hardest part of getting a scheduled contract is getting the contractor internally to get all the documents they need to process their offer and then to submit to the federal government. Once the offer is submitted to the federal government, there will be negotiations and clarifications and discussions with the contracting officer or contracting specialist responsible for that solicitation. But by and large, the hardest and longest part of the process is internally having the company get all the information it needs to submit an offer that's complete and accurate. Once the contractor's offer gets it, they'll review it, come back to you with any questions, have discussions, and then after that, they'll issue an award. Usually, 3 to 5 months is sort of the general time frame. Could be shorter, and it certainly could be longer. Certainly, to maximize your sales under the contract, there's no certainly secrets here that you don't ordinarily do with your commercial customers for those companies that are operating in both the commercial space and government contracting space. And if you're getting a schedule contract, chances are you have some commercial customers. It's just, creating and building that relationship with your federal customers, helping the agency understand what its needs are and requirements, and helping shape those requirements by demonstrating the return on investment as an example, but also demonstrating why your products and services provide more value than perhaps your competitors. As I said, nothing that you probably are not ordinarily doing in the commercial marketplace. One benefit of the GSA schedule is they have an online catalog called GSA Advantage, which contractors are supposed to upload within the first 6 months of contract award. You would be surprised on how many contractors don't take advantage of the GSA Advantage website. This is a tool that's right at the disposal of the contracting officers. If they're looking for a particular product or service, they can go online, which most people shop with these days. They'll look at the schedule, and if you're not in GSA Advantage, I think you're putting yourself at a significant disadvantage. So we would recommend trying to get into GSA Advantage as frequently as possible. You can update your GSA Advantage catalog anytime you want, and it just gives contracting officers another tool, and purchasing folks another tool to acquire your products and services.
If you're going to be a GSA Federal Supply Schedule contractor, you're going to learn that it's like being on a toll road. You can't be on this road, you can't be driving it without paying for it. And the way you do it is you pay the what's called the IFF, the Industrial Funding Fee. This fee is paid by the agency to cover GSA's administrative and program costs of administering the schedule. And it's paid through the quarterly sales reports that you as a Federal Supply Schedule contractor are going to be filing, and as the slide makes clear here, you want to do these timely. They'll be all over if you don't. The IFF is actually incorporated into your price. It currently stands at 0.75%, and you got to have people watching this on a regular basis, because you can get tripped up on this thing, and GSA is very careful to make sure its contractors are paying the IFF fees. They'll audit it, and as we say on the slide here, they'll generally audit your IFF payment performance on an annual basis, although it's inconsistent. And the slide here indicates it might never happen, but you need to treat it as if it's always going to happen. You're far better off if you do. And they'll perform these audits during contractor assistance visits that they will make on occasion in advance. It's not a surprise visit. And if problems or inconsistencies crop up or are detected during these visits, you can expect follow-up audits. They're pretty rigorous about that now that they have flagged you. Now, the audit these kinds of audits focus on two things. First of all, they track all the invoices for all your GSA orders, and the reports that make sure that the report schedule sales are correct. And they're looking to make sure that the correct payments of the industrial funding fee have been made to GSA.
And Tim, if I could add one or two other points, usually these IFF audits for the contractor assistant visits, they're done by an individual known as an industrial operations analyst, or an IOA. Those audits usually take place over a day or two, more like a day, but we've had instances where they've extended to over 2 days. The result work product from the auditor is usually what they call the report card. It's a 1- or 2-page document sort of setting forth your compliance with a host of categories in terms of, are you calculating your industrial funding fee correctly? Are you reporting it properly? So on and so forth. And that report card, the current version of the report card, is available on GSA's website. If anyone's interested in seeing a copy of it and you can't find it, by all means, let us know and we could send you a copy. And sort of the most important point that I'd like to add regarding the industrial funding fee in these audits is that they really have been expanding in scope. As Tim mentioned, generally speaking, they're designed to determine whether your 0.75% is being paid pursuant to your GSA sales. We've seen several instances over the past, year to 18 months where these IOAs are coming in and trying to expand the scope and focus of the audit. Our best sort of general guidance is you want to cooperate, but you also don't want to be taken advantage of. And so you have to decide when you want to pick your battles. I think by and large, if they're asking for additional information, you can share it with them. But once again, that audit scope is limited, and you need to be careful on what you provide to the IOAs as they're coming in through the audit process. If I could turn now to the commercial sales practices, and this perhaps is, to me, the most important document you will fill out when you are submitting an offer for a GSA scheduled contract award. The Commercial Sales Practices Form, or the CSP1 form as it's known, is usually an attachment to the contract solicitation on the GSA website. It's usually buried in one of the attachments, but all the CSP1s throughout GSA are essentially the same. It's a multi-column chart that looks for your contractor pricing and discounting practices. They'll ask for who your types of commercial customers are, the discounts, the concessions you will offer, regardless of volume or special terms and conditions. This information is used by GSA to evaluate your pricing and to negotiate fair and reasonable pricing that's established at the time of contract award. One critical piece here is to make sure that the information that you're providing in negotiating your scheduled contract is sort of supported by the appropriate documentation within the company. And that's a theme you'll hear a lot about from now till the end of the presentation and throughout today. And that is, you need to have good record keeping if you're going to have a GSA scheduled contract. Because if you're audited, they're going to ask for all these records. And you need to have, whether it's the simple IFF audit, if I could call it simple, to a full-scale Inspector General audit, which not to scare anyone, but the Inspector General handles the full-scale audits for GSA as a matter of course. It's not your traditional IG audit that government contractors normally think of. So it's really good to have good record keeping. Our rule of thumb is, when in doubt, disclose the information in the commercial sales practices form. This gives you the ability to have that discussion with GSA at the outset. For your types of customers that you have to disclose and that are ultimately chosen for your most favorite customer, which we'll talk about in a few minutes, we recommend having a narrowly defined customer as opposed to sort of all commercial customers. It will help sort of in your schedule compliance, and we'll talk about that in a little bit as well. Certainly you have an obligation to update your schedule contract, your CSP, both before award and after award if things have changed. And there's not a one-size-fits-all approach in terms of telling you how to fill out your schedule contract, because each company is different. They have different, pricing and discount practices, but they also operate in a different industry. So folks who are in the transportation or trucking industry who are providing that service on the schedule is very different from those that are providing computer monitors and other IT peripherals under a schedule contract. So what happens if you fail to accurately disclose your information under your commercial sales practice? Well, in the event of an audit, GSA will look to see if you provided complete and accurate information. We can tell you from our own experience that GSA wants to see everything when they come in to do an audit. And once again, that gets back to that balancing test of being cooperative, but at the same time knowing what your rights and responsibilities are in responding to an audit. And often, excuse me, they will, the auditors will make the case that if they've had a certain level or omitted information that was not contained in your schedule offer, they could have negotiated a lower price. And sometimes those arguments border on the nonsensical, and sometimes they are valid. And it's just a question of what information did you provide to the contracting officer when negotiating your commercial sales practices form and determining who your most favorite customer or basis of award customers. And so, failure to provide the information will lead to a claim of defective pricing. And what is defective pricing? Defective pricing is when you do not provide current, complete, and accurate information under your scheduled contract. The problem with that, if that was the only issue, oftentimes contractors could manage that in the vacuum. But it doesn't exist that way. It doesn't exist in a vacuum. And defective pricing questions often lead to expansions of the audit into a host of other compliance areas and a host of other directions under the GSA audit. It certainly, as I note on the slide, can move from the OIG to DOJ, Department of Justice, if they think there's some higher liability or greater liability, perhaps some False Claims Act liability or some false statements liability under the contract. And with that liability comes potential for additional civil and criminal penalties. In addition to penalties that I just mentioned, it could include a price adjustment, and the price adjustment provision under the GSAR is at 552.215-72. Those penalties can arise for failing to provide accurate and required information, if the information is outdated or not complete in any manner, and if changes to pricing on your discounts or concessions have been made after submission, but prior to the completion of negotiations or after contract award, you do have an obligation to update your CSP. So if you get an award on June 1st, 2015, and 3 years go by and you've made a number of changes in that interim period and you haven't updated your CSP1 to your sales and discounting practices, you could have some exposure. And certainly it could be significant for those contractors who are making, a number of sales that have been performing under the contract for a long period of time prior to a GSA audit or prior to realizing you have to update. There is that potential liability for a retroactive price adjustment to the contract.
One of the most confusing areas relating to the federal supply schedule is what we'll call the most favored customer issue. We're trying to get that slide up right now. There we go. And it's really a misnomer, the most favored customer label. So let's talk through it. If someone tells you, even if it's someone from GSA, that you're supposed to give the government your best price possible, that comes with an asterisk. That comes with a caveat, and that is that, for example, let's say that your biggest customer is a major airline and you sell 10,000 of your widgets to them on an annual basis, and GSA estimates that they're going to buy about 1,000. The market research shows that they're good for, the feds are good for about 1,000 a year. There is no way that you are required to give the GSA buying 1,000 a year the same price that you're giving this major airline buying 10,000 a year. So you're looking for comparable customers, customers that fit the profile of the business you expect to be doing and GSA expects you to be doing with them going forward. And we'll call it the most favored customer pricing, but again, it's under the same facts and circumstances. And the fact, obviously, you're going to hear from people that it's the U.S. government here, it's the largest purchaser anywhere, but it isn't always for particular items. And so you've got to protect yourself on this. The most favored customer nomenclature can be used, we have different names for it, most favored nation pricing, lowest provided or guaranteed pricing, but it's all talking about giving your customer the best price under similar circumstances. Now, so that means that it's this price that you're going to be negotiating with the GSA is based on comparable terms and conditions among your own commercial customers. Now, GSA is going to look at all the data you're providing, and they're going to compare the pricing you give your other customers to what they're getting, and you're going to be disclosing all this information to them. Don't hold anything back, because as Jeff hinted at a little bit ago, that could lead to problems going forward.
And Tim, let me just add one point on this apples-to-apples comparison. We need, or contractors, as I mentioned before, should really have narrowly defined categories of customers, because to say all commercial accounts or to say, all contractors in a particular industry is just generally too broad of a category of customer that you can't narrowly define your customers to, as an example, Walmart or national accounts or ABC company. That's much more beneficial to a contractor, because then when you're looking at who the most favored customer is, you have a tangible set of information that's much more readily available for the contractor to provide to GSA.
Thanks, Jeff. That's a great point. We're actually going to cover how this is done right now on the slide that's just come up, and that is that you're going to do your best to reach an agreement with GSA on which particular customer or category of customers should be the profile or comparison group or customer for purposes of your pricing. And let's just say that's company X, one of your biggest customers. Now, the price that GSA is going to be agreeing with you on will probably be the same price that you've got with Company X. And they're going to get the same discount. And so they become your most favored customer basis of agreement. That's what I call the profile customer, or the basis for your agreement. And what that means, frankly, going forward, is that during the period of performance of your Federal Supply Schedule contract, if and when you change anything to do with that most favored customer, that profile customer, you must notify GSA of that in a timely fashion, and you must give them the same treatment. Now, if you don't, that leads to another very famous issue in the Federal Supply Schedule world, and that's what we call the price reduction clause. Now, you notice this slide calls it the dreaded price reduction clause. That's not actually in the title that you'll find in the regulations, but this is a product of experience with the agency when they discover that a company has in their minds run afoul of the price reduction clause, which in the first bullet there on this slide we see is at 552.238-75 of the GSA Federal Acquisition Regulation Supplement, the GSA FAR. Now, the purpose of this clause, and Jeff's going to talk about some proposed changes to this clause before we close today, but the purpose of this clause is to maintain the price/discount relationship that's negotiated at the onset of the contract, and make sure that that price-discount relationship is maintained throughout the course of the contract. And that can be 20 years if the options, if these things are renewed over a period of time. And it's very important that you make sure you've got the records to show that your pricing practices and discounting practices have not changed with respect to this particular customer. We have an example here. Let's say that we give a discount to your most favored customer, Company X, at the time of award, and that's 15%. Now, after you've gotten the award of the GSA Federal Supply Schedule contract, you decided, or in negotiations with this customer, you increase the discount to 20%. Well, you guessed it. You've got to notify GSA that this happened. You must disclose this, and you must offer them the same discount. Now, I'm not going to suggest that they aren't going to take it. They're going to, but you've got to offer it. Now, the same philosophy applies to any reductions in your contractor pricing and what you're doing, offering a more favorable terms and conditions to that particular customer found in the price lists or catalogs, or other similar contractor documents. And I might say here that in our experience, this is probably the #1 trap or trouble area for schedule contractors. And it's not because they're dishonest. It's not because they're incompetent. It's because they're often far-flung, and they reach these agreements with the Federal Supply Schedule people, and they don't properly train the sales force and sales management around the country as to what's just happened and what this means going forward. And the last thing you need is for GSA to conclude that you've done nothing to either train your personnel or set up a system which is designed to catch these things when they happen, because we all know that aggressive marketers will make promises and do things just to get a deal. But if that's going to put the whole company sideways with this price reduction clause, it could be an expensive deal for the company.
And what does Tim mean by expensive? And expensive means that the reduction can extend to the same effective date and for the same time period as extended to that particular customer. So as an example, in Tim's example, if in fact on June 1st that 5% delta was provided to a customer and it was not disclosed for a period of a year, and that new pricing scheme or pricing paradigm was utilized, that's a retroactive price reduction that has to be granted to the federal government under the price reduction clause. Now, one of the issues is, I mentioned before, where there's smoke, often there's fire. At least that's what GSA thinks. So if you come back to them over a year later with the disclosure that there's a price reduction problem, in some cases they'll say thanks very much, or remit the payment. Other cases they may decide to dig a little bit deeper into your sales practices and discounting policies to see if there's anything else there. So once again, it's very important to catch this at the outset, and with the advent of the computer systems and the technology and the financial software packages, there are a host of technologies that could help facilitate this contract compliance. But there are some exceptions to the price reduction clause, and we have these on the slide in front of us, and the regulatory citation is included if you want to look at these afterwards. I'm going to skip the first one to, exceptions for commercial customers under FFP or firm fixed price definite quantity contracts for a moment. Let me just go to the other three, and then I'll come back to the commercial customers one. You certainly can always give a greater discount to federal agencies. If you have a schedule contract that says it's $100 per widget, and because you want to get rid of some items, or you are feeling especially charitable, or you just wake up one morning and had a good breakfast and you want to give the Department of Defense a 70% price reduction, and you want to charge $30 for that item, you're entitled to do that. That does not trigger the price reduction clause at all. If the sale is made to a state and local government when the order is placed under a scheduled contract, and there is and the state and local government serves as the basis of award customer, that is also permissible as a carve out from the price reduction clause. And certainly if there's a mistake or an error in billing or invoicing or quotation, you could avoid the price reduction clause trap. I want to get back to the first one here because there's really four parts to that exception. And that is the no price reduction for sales to, number one, to commercial customers. So they have to be a commercial customer. Number two, under a firm fixed price, definite quantity contract. So it has to be a fixed price under a definite quantity contract that is where the quantity is established at the outset of award. And where there is specified delivery, so delivery is going to be determined as set forth in the contract terms and conditions. And then in excess of the maximum order threshold, the MOT that's specified in the contract. And every GSA schedule contract has an MOT or a maximum order threshold. Usually it's not a significant number for a lot of contractors, $250,000, $150,000, just to give you sort of the sense of the scope of that number. And it varies a little bit on either end. But, if you're selling, a fairly significant level of services or costly items or supplies, generally meeting that MOT is not difficult. It's meeting the other three prongs of that exception that come into play. For those selling more commodities, office supplies, paper clips, pencils, basic IT equipment, that number is a lot harder to reach, and the sales need to be at that maximum order threshold to qualify under this definition. In addition to actual sales and discounts that you may give to federal agencies, as alluded to in the exceptions, you always can offer the government a price reduction under the scheduled contract. So under the exceptions, it's sort of referring to a sort of one-time event that could happen repeatedly. But the last bullet point on this slide, where we can always give the government a price reduction under your contract, that's if you wake up one morning and decide you want to lower your pricing to your federal customers, you could offer them that discount, and that won't affect your price reduction liability.
Jeff, before we go any further, I wouldn't want any of the listeners, and I saw the attendee list before we started today, and I'm sure that many of you I know that many of you are already on the schedule, and so you're veterans of the process. But I would say that for anyone who isn't and is looking to get onto the schedule, don't for one second think that it's just standard run-of-the-mill supplies and items like towels and things that are on the federal supply schedule. First of all, as Jeff has mentioned a couple of times, there are services on here, and it's not just car washing or whatever the janitorial services might be. It is some pretty sophisticated stuff that's available through the federal supply schedule now, and it is often surprising to read through the types of things, the sophistication of things that are on this schedule. So if you think your product is too sophisticated to be on the federal supply schedule, take a look at it. You might be surprised.
And I will emphasize that every time I think there's a product that a client or a contractor will ask us about, and you do a little digging. Sometimes the product or service may not specifically be mentioned on the schedule, but certainly can fit into one of the, numerous schedules that are listed on GSA website. I will tell you, I was shocked to learn a few months ago that the federal government is, or under the schedule, drones, unmanned aerial vehicles are now on the schedule, and I can tell you that they're looking for more schedule providers in that area. So for any drone manufacturers, there is a schedule for drones or UAVs.
Okay. Well, obviously, if you're going to do this business in any serious way, you want to avoid triggering the price reduction clause. And the slide that we've got up there now gives us a couple of pointers on how that can be done. First of all, obviously, your price reductions that you're giving to your basis of agreement to your profile customer need to be reflected in your schedule contract, period. That's a starting point. You also, we wouldn't want you to believe that because this is let's just say a streamlined methodology for government purchases, that somehow it doesn't have the same issues that the big government contracts do, the terms and conditions and things. The fact is that the rules that are followed by the major DoD contractors have their own applications to the contractors that are on the federal supply schedule, and it starts with documenting your files. You want to document and make sure that if that audit comes or a knock on the door comes from an IG, that you can go to the files and go to the computers and pull up all the information you've got on the relationship you have with your basis of agreement customer, the pricing and the discount relationships you have with them. You want to be able to document that. The last thing that auditor is going to want to hear is someone who says, give us a couple of weeks, we'll put that together. That is a red flag. So you've got to keep your documentation in a very detailed and thorough way and keep it for a long time, the life of the contract. The documentation obviously has to ensure that you've got price consistency. And let me just say that it's one thing to have documentation, but you have to have intelligent humans, men and women, working in your contract administration group who understand what this documentation is there for, who understand what the relationship is with your GSA customer and the agencies that are ordering through that GSA contract. Just because this is a simplified process doesn't mean that contract administration is any less important. In fact, I would say that if you treat GSA like you treat your other commercial customers, you're going to have trouble. This is not a commercial customer. This customer has teeth. And you'll be bitten if you don't have someone in your group watching what goes on with the sales under the federal supply schedule. Jeff put together this slide, and he mentions that an ounce of prevention is worth a pound of cure. Of course it is. And in fact, in this case, to have an adequate system is one of the first things the auditors are going to look at when they come in. And if they see it, you're already at the 40-yard line, with a football analogy. If they don't see it, you're way back and you're looking at a touchback or a safety. You've got a problem. So that system is very important to you. Now, there are in the offing right now some changes to the price reduction clause, a proposed change. Jeff is going to address that before we're done. But that isn't anything to worry about right now. You've got to focus on the existing clause. That's always going to be the clause that's in this contract that you're performing right now if you're on the schedule now. It could be changed in the future, but right now you focus on this, set up the system to protect the company to the utmost, and train your people.
As Tim mentioned, the price reduction clause, or the dreaded price reduction clause, is probably the #1 snafu or problem child in dealing with the GSA schedule contract. I would say the #2 problem child in dealing with the federal government contract is the Trade Agreements Act clause. 10 years ago, 15 years ago, nobody was really worrying about the Trade Agreements Act clause. It was a clause that was set forth in the contract, sort of in the back with all the flow downs, and no one really paid much attention to it. But there has been significant enforcement with significant penalties, especially over the last several years, dealing with the violation of the Trade Agreements Act. And what is the Trade Agreements Act? Well, the Trade Agreements Act simply says that scheduled contractors must certify that all their products and services under their contracts are made or substantially transformed in eligible countries. And what that means is, as set forth on the slide, is that the name, character, or product or character of the product is substantially transformed in a quote-unquote friendly country. A friendly country is one that the United States has entered into a trade agreement with, either bilateral or multilateral, and it allows those countries to be treated on a very similar basis as the United States is when doing business in those foreign countries. And it's a fair trade agreement set of provisions. You know, eligible countries, they're all listed in the FAR under Part 25. You'll see all the different Trade Agreements Act, both, as I said, bilateral and multilateral. The key here, and where people have got, or contractors have gotten themselves in trouble, is when they have their products manufactured in China. China is not eligible to certify that you are compliant with the Trade Agreements Act. Here's the reference in particular, 52.225-5 and 6, and the corresponding regulation at FAR Part 25 will set out the Trade Agreements Act and a contractor's obligations under that. Now, to establish whether or not a widget was manufactured and produced either in the United States or or substantially transformed in a Trade Agreements Act country, it's a fairly extensive review that has to go on. What you have to do is look at the manufacturing process through the cost of that process and the steps taken to undertake that process. Please be aware that mere assembly is not substantial transformation. So if you have a box of parts that are manufactured in China, and that box of 12 parts are sent over the United States to Sheboygan, Wisconsin, and the people in Sheboygan who all have high school degrees open up the boxes, lay the 12 parts on the table, put 11 of the parts together, take the 12th part and glue it, and then put a battery on the part. Generally speaking, that's not going to constitute substantial transformation. There has to be some more rigorous process in that, and to sort of analyze and assess whether substantial transformation occurs is a fairly, as I said, significant process. You have to assess not only the factual circumstances, because they are done on a case-by-case basis, but also you look at similar U.S. Customs and Border Protection opinions that outline facts and circumstances for similar products that are being offered to the federal government, and whether those are in fact substantially transformed or not. Protective measures that contractors can immediately take to ensure or minimize liability under the Trade Agreements Act is for those relying on suppliers who are providing products and services, make sure you review and update your letters of supply from the manufacturer or supplier. Within your agreements with those manufacturers or suppliers, you should have indemnification language that says if there's a Trade Agreements Act violation due to their products or services being manufactured in a non-Trade Agreements Act country or not the United States, they have to indemnify you for any liability resulting from that breach of the Trade Agreements Act. And within a company who does not rely on suppliers or manufacturers, you should review your own internal sourcing and manufacturing data to ensure that if it's not manufactured in the United States, that substantial transformation has occurred where applicable. And if you remember, many of you who have scheduled contracts probably remember back to the Office Max, Staples, Home Depot set of cases where those companies were providing pencils to the United States government. The government suffered zero damages. The price they paid for those pencils was less than what they could have got from the company who bought the case, which is located in Texas. Those companies were all fined in excess of $10 million for manufacturing pencils in China. So there's significant liability from this clause. Contractors, I think, are getting much more attuned and aware of this liability and have gotten a lot better over the past couple of years, but it's something that you all should take very seriously.
Jeff, and I might add that there's a lot of confusion about this Trade Agreements Act, the TAA compliance, because people just bunch it into one sentence with Buy American Act. But the fact is that under GSA Federal Supply Schedule contracts, the Trade Agreement Act is the only trade provision that applies to it. Buy America does not apply to the GSA Federal Supply Schedule contracts. And they're both very tricky to work with. To have two of them to work with would be a killer, but you don't have to worry about Buy American under the GSA Federal Supply Schedule.
And they're, to that point, they are two separate and distinct statutes with different requirements, different provisions, and frankly, different definitions. And the definition for the same term is different under the Buy American Act and as opposed to the Trade Agreements Act.
Yeah, thank you for that. So it's easy to confuse. Just make sure that you keep them straight. The sanctions for noncompliance can run anywhere from price adjustment, which I would say in this case is probably the best thing that could happen to you, because as you go down this list of 6 or 7 things, they're all pretty scary. Termination for default or convenience. Now, for those of you who aren't really familiar with the world of government contracting, a termination for default is just about the worst thing that can happen to you because it stays on your record for 3 years in terms of what we call your past performance record, and your ability to win contracts after you've got a termination for default is severely hampered. So that's a bad thing. A suspension and debarment, yep, that is an awful thing that's peculiar to government contracting, and if the government should conclude that your actions were intentional, you've probably got a major risk here in terms of suspension or debarment, where literally you will be out of the business going forward. False Claims Act liability, there's both a civil and a criminal False Claims Act out there. Treble damages if it's civil liability, and let's just say that they have been damaged to the tune of a couple of $1 million bucks. That could be a major problem for you. False Statements Act liability. Did you lie on your proposal? Did you lie in the documentation you presented to the government? Did you lie on a particular invoice? Again, these are not things you want to get caught up in. FAR Subpart 3.1 talks about the integrity and the honesty of contractors. That's a huge issue in government contracting, and the agencies are monitoring this in a very, very strong way these days. And last but not least, you don't like to think about it, but criminal prosecution. There are stories on an occasional basis throughout any given year of companies who have run afoul in the government contracting world, providing for example, medical products from Pakistan or things like that, where they have simply miscertified the authenticity of these products, and people will go to jail for that. So it's just a way of saying compliance is critical. It's absolutely critical. If you're going to be in this business, you're in for a dime, you're in for a dollar. You got to train your people, and you have to make sure that you're refreshing them on a regular basis. The contract renewals, we talked about how your contract probably is for an initial period that could go to 5 years, but it can be extended for up to a total of 20 years under the evergreen clause in your schedule contract. And when it comes time for these extensions, they're going to come in, more than likely, the Office of Inspector General at the GSA is going to come in and do an audit on your books. So once again, your books have to be current, your books have to be complete. They've got audit rights under the clauses that are mentioned on this slide, and they're probably going to look back 12 months. But don't throw out data that's just 12 months old the minute it goes 12 months in 1 day. Keep it so you got to protect yourself in case of an audit.
On the IG audits, you know, Tim mentioned they go back 12 months. Certainly that is the norm. We have seen situations where they've gone back to the beginning of the contract period, and in some cases prior to the contract period, in the former contract period. There is one instance where I think contractors have the right to sort of ask to limit it, certainly back to the beginning of the contract period, if at all possible. I mean, collecting this data is awfully voluminous in the first place. Going back outside of the contract period, I think, is a little bit beyond the bounds of reasonableness, and unless there's a reason to do so at first blush, I think you could push back. But let's talk real briefly about the IG audits. More than ever before, we're seeing IG auditors coming on in years, 3.5, 4 of the contract to audit scheduled contractors. And these audits, I think, are increasing in part because of the volume of business being done under the schedule. As I noted to before, once you hit a certain threshold, certain schedule contracts, as a matter of course, are now sending the IG auditors to review the contracts. For those of you who have had to deal with IG audits and talked to the auditors in the past, you know how busy they are, and getting a hold of them to focus on your particular contract once they've done the audit, or if there's a problem with the audit that you're trying to negotiate a resolution to, it's very difficult to get their attention. I think they are extremely backlogged. I think they're extremely short-staffed in terms of auditing contractors, because I think part of that is due to once you hit a certain threshold, those scheduled contracts are automatically being audited. I think the scope of the review is being brought in like never before. Before, you may have seen a request for data back 6 months to a year, just under some sales, and they would do sort of something more than the IOAs did under an audit. Here, they're looking for all the documents that are really included on this slide: request for quotes, quotes themselves, task and delivery orders, purchase orders. They're looking for subcontractor agreements to look at your pricing with subcontractors, other ancillary agreements, BPAs, pricings are under your BPAs, invoices, price lists, really the full gamut of documentation. And I think once again, as a matter of course, it's valuable to try and cooperate with the auditor, but at the same time, having those records in a single place with a single person or persons who have responsibility for those documents is critical for a successful audit. You also want to give yourself a sufficient amount of time to review your pricing and sales data prior to the auditor coming in. We say here on the slide at least 6 months worth of data and documentation, certainly if not a year, as we mentioned before. If the auditors come in, it could be for a few days, or it could be up to a week, we've seen, where they'll come in sometimes for a morning on a Monday, disappear to Wednesday, to come back, finish up Thursday, and then, it could take 6 to 8 months to sometimes get an audit report back, sometimes longer. So it's, once again, just depending on how backlogged the auditors are, is when we will, complete the audit. 3 high-level items to mention as you prepare for your audit, and that is, has anything changed with respect to your, commercial sales practices that you disclosed at the outset of your scheduled contract? That goes back to one of our earlier discussion points about the commercial sales practices and how important it is to provide a complete, accurate document at that time, but also to update it accordingly. If you have had changes in your contract, during the audit process, you can use that as a sword as opposed to a shield, and take this opportunity to update these practices, especially if they changed, and as part of the negotiation process to complete the audit. And if you go back and look at your CSP 2 years or 3 years after you've done it, or 6 months after you've done it, and you realize, well, maybe this wasn't as clear as it should have been, or I think, we may go into a different line of business. Maybe we should sort of think about changing our CSP at this time. Now's a good time to do it. Under the guise of the audit, you could have those discussions with the auditor and your contracting officer and be able to sort of make those changes. But at the end of the day, having the appropriate records and documentation and making sure you're prepared for the audit to provide the auditor with what he or she needs will sort of maximize your ability to complete the audit in a more timely manner, but also to get through it without any additional liability.
Well, I know we're running out of time here. Slide 24 lists the types of documents that you ought to have in addition to the documents that were listed on slide 22. This might not be obvious to someone who is an experienced contract administrator, but clearly these types of things can save your bacon in the case of audits that come up. When they're missing, they cause problems, and they're suspicious. So that list is a very important list for you to keep in mind in terms of trying to protect the organization. Moving to slide 25, if you haven't done it, the sooner the better in conducting an internal compliance review. And we have a list of the practices and the things we think you ought to take a look at there on slide 25. But in my view of that list, the item on the bottom actually is where you start. Read the contract first. Make sure you understand the contract. Then work through the other items on this evaluation ladder, and you should be in good shape. Now, you might find that you're not in good shape, but at least you've caught it. You can correct it now, and you're moving forward from there.
And I know we're pressed for time, but this has to be emphasized. The last point on this page with the exclamation point is reading your schedule contract. So often the time we have folks come to us and say, we have a problem with our schedule contract. You know, we're sort of frustrated. We can't make any headway with the contracting officer. And we'll say, what does your schedule contract say? And the individual says, well, we've never read it before. We don't know what it says. So really read your schedule contract. You can avoid a lot of problems in the future. Well, you know, in terms of, the evaluating your compliance, you certainly take the opportunity to review all of your scheduled contracting practices. Getting back to your initial filing of the CSP and all of the, underlying support for those documents, that's a great place to start to review and analyze your accounting, sales, and contracting data. Training is essential. Training is, without training, you can educate your employees. You can educate your employees to make sure that they are compliant with the administration of your scheduled contract. There are online courses, there are webinars, there are people come in and do the training. As I said, there are a whole host of training. Make sure your people sign into the training. You keep records of your training, and you could use that as a support in an audit that you are training your employees. What systems are in place to assist with your compliance protocols? I mentioned before, the software packages that are out there are very helpful, because when an auditor sees that you have an electronic system that tracks your sales, well, sometimes we'll even flag a sale if it looks like it's outside of the pricing parameters that you've instructed the system to catch. That's very helpful and very supportive of your good compliant contracting practices. And once again, a periodic review of your scheduled contract on an annual basis is fundamental to successfully evaluating your compliance. And I'd say last and certainly not least is a latest development that Tim has mentioned at the outset. In fact, it's very timely because on Friday of last week, there was a public meeting about the proposed rule to change the impact of the price reduction clause. We sort of discuss on this slide what the tone and tenor of the rule was. It really was a shift away from the most favored customer or basis of award contracting approach to the collection and use of transactional data, which is really the use of a broader set of data other than just sort of a particular customer or category of customers. It theoretically is supposed to reduce the burden on scheduled contractors and their price monitoring activities by relying on what other contractors across the schedule are providing and what the scheduled contractor holders' particular pricing is among its category, wide range of customers as well. Essentially, it increases the analysis on the horizontal pricing approach that contractors are using, both internally and through more of a commercial industry-wide basis. I will say that with this proposed rule, the price reduction clause still is alive and well because in essence, this is still all about the lowest price. At the public meeting, there was acknowledgement by GSA that they are still looking for the lowest price, and as we note on the second to last point on the slide, GSA still reserves the right to ask for traditional CSP information if there's not enough information to establish fair and reasonable pricing. And for those of you who have dealt with contracting officers and negotiated these commercial sales practices provision in the past, you know how difficult that negotiation can be in many cases to determine fair and reasonable pricing based on your normal or standard contracting or pricing practices. And finally, certainly this rule merits careful consideration and caution perhaps would have been a better word, because this proposed rule relying on the transactional data as opposed to the best price concept may be a distinction, but really without much difference in terms of GSA's evaluation for price reduction purposes. Well, with that, we have one or two questions that I think we can answer real briefly. For those of you who have to go at 2 o'clock, we thank you for your time. But for those who want to stay around, let me just sort of respond to the two questions that were provided. The first is, do I get notice at the company for an audit taking place? And the answer is yes. They just don't, GSA just does not show up on your doorstep. The IOA and both the IG will send notices to you that you've been selected, isn't that a nice term, selected for an audit. and that they'll provide the list of documentation that they'll provide. An IOA audit, as I said, is much simpler, and they'll provide sort of usually the list of information relating to the industrial funding fee and your commercial sales practices data that they'd like to see. I often view that as you'll prepare a lot of spreadsheets for that audit. For the IG audit, you're going to get probably a 3 or 4 page letter with an attachment that's probably 4 or 5 pages, much of which contains the types of documents they're looking for in both electronic format and the other format that they want. Once again, feel free to ask for clarification on some items, because sometimes they're boilerplate requests that are used on every auditor for every contractor that don't make sense to you as a company, and certainly you could clarify or look to limit that audit. The final question is, how do I find the schedule listings on GSA's website? The easiest place to go is to go to GSA eLibrary, all one word, .gsa.gov. That's the website that provides you with the list of scheduled contracts. There's actually a search box. You could search for your own schedule. You could search for competitor schedules. And within that, you can look to the different contractors and competitors that are on the schedule. You could click the particular offerings to GSA Advantage. There's a link on those websites, and you can have access to the GSA Advantage to see what what companies are listing what products. And the final question is, I have a distributor that I have a relationship with, and the government is saying that I need to have the lowest pricing that the distributor has for the government customers. The answer to that question is that's not a true statement by the government. Distributors often provide value-added services such as maintenance, warranty work, inventory control, marketing, all sorts of value-added services. So if the government is saying they're entitled to the same pricing as distributors, if they're not providing those services, that's not a true statement. And I've had several instances where we have advised clients and successfully advised clients that the distributors can get the lowest price. The government will always ask for the lowest price, but they also recognize that they're not entitled to the lowest price in all circumstances. Those circumstances can be certainly in the distributor context, where those distributors are providing services that the government can provide, or, as Tim mentioned earlier, are purchasing in volumes that the government just doesn't purchase under.
Thanks, Jeff, and thanks all of you for hanging with us beyond the 60-minute mark. We hope you enjoyed our time together this afternoon discussing the federal supply schedule, and we wish you all the best of luck. Thank you very much.